Honorable President.
Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation. Announcements by the President.
Honourable Senators, I have granted leave of absence to Senator David Small, who is out of the country. Honourable Senators, with your leave, I will defer until later in the proceedings the swearing-in of the temporary senator.
Petitions, papers.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in my name. The ministerial response of the Ministry of Agriculture, Land and Fisheries to the third report of the Joint Select Committee on Land and Physical Infrastructure, third session 2017-2018, 11th Parliament on an inquiry into the strategies for diversifying the type and number of agricultural commodities produced locally. And secondly, the ministerial response of the Ministry of Agriculture, Land and Fisheries to the fifth report of the Joint Select Committee on Social Services and Public Administration, third session 2017-2018, 11th Parliament on an inquiry into the adverse health effects of fireworks. I thank you.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following paper as listed on the supplemental order paper in the name of the Minister of Health. The ministerial response of the Ministry of Health to the 17th report of the Public Accounts Committee, third session 2017-2018, 11th Parliament, on the examination of the audited financial statements of the Trinidad and Tobago Bureau of Standards for financial year 2009 to 2013.
Reports from committees.
Senator Amin.
Thank you, Madam President, and may I welcome you back. Madam President, I have the honor to present the following report as listed in on the order paper in my name. The 10th report of the Joint Select Committee on Local Authorities, Service Commissions and Statutory Authorities, including the THA, third session 2017-2018, 11th Parliament, on an inquiry into the internal controls, systems, and corporate social responsibility policies of the National Lotteries Control Board.
Mr. Vice President.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The interim report of the Joint Select Committee appointed to consider and report on the Constitution Amendment Tobago Self-Government Bill 2018.
Minister of Agriculture, Land and Fisheries.
Madam President, I have the honor to present the following report as listed on the supplemental order paper in my name. The report of the Joint Select Committee appointed to consider and report on the Income Tax Amendment Bill 2018, the Mutual Administrative Assistance in Tax Matters Bill 2018, and the Tax Information Exchange Agreement 2018, together with a minority report. I thank you.
Urgent questions.
Senator Mark.
Thank you very much, Madam President, and may I join in welcoming you back to this Honorable Senate. To the Honorable Attorney General, can the Attorney General indicate when manual searches for land titles will be resumed at the Registrar General's Department?
Attorney General.
Thank you, Madam President. Madam President, I'm very pleased to inform that the move of 8 million deeds, 7,000 RPO volumes, 4 million life and death certificates, birth certificates, adoption, etc., and 90,000 company records is well in tow. We expect in that move time to be able to open the manual search side of the registry in stages. Firstly, the real property ordinance documents ought to be completed and moved by today, and the unpacking onto shelves within 1 week, and we can open that. And secondly, in terms of the land registry, which is again a 5 million documents portfolio, we're hoping again for a further 2 weeks beyond that. We are anticipating that we'll be able to beat our deadlines, but suffice it to say, it is a very careful exercise that is unfolding because we must barcode and document every document that is leaving and going and its proper receipt. Thank you.
Senator Mark.
Yeah, Madam President, I know this is a very meticulous exercise that the Attorney General and his staff would have to undertake. But could the Attorney General indicate the kind of inconvenience it is causing to officials who have to conduct the necessary title searches to ensure that transactions are executed on a timely basis? Has the Attorney General taken that into account?
Thank you. I met with stakeholders, search clerk, the Registry Search Clerk Association, the Law Association, the Bankers Association, and members of the public. In fact, I just came from the registry. We've been working 24 hours a day. We've enlisted the facility cooperation of the TTDF. But what we're engaged in right now, Madam President, is an exercise that has never been done before. The barcoding of documents is something that simply was never done. The records of Trinidad and Tobago were not done on an inventory basis. The system that we're using right now allows us to track a document exactly where it is on a shelf. And therefore, we are improving the ease of doing business in a way that has never happened. I might add that there is an inconvenience, obviously, which was catalyzed by the earthquake, which was an unprecedented event. What we have, however, is the full functionality of the online system. So there is the full electronic search on the Property Information Management System, referred to as PIMS. We expect this week to be able to open the in-house version of PIMS that is at the registry at the AGLA campus at Richmond Street. All in all, this mammoth exercise undertaken, we have already opened the registry. Online searches are completely functional. Up-stamps are fully functional already. Issuance of duplicate CTs are already fully functional. The RPO volumes have been moved as of today, and the old law, which is 90% of the registry, will take us, as I indicated, a couple weeks extra because the unpacking of the exercise is there. This was something which was catalyzed by the passage of the earthquake, which of course interrupted our pre-organized plans to do this 2 months later. We are well on track, if not beating the track that we have indicated to all stakeholders.
Senator Mark.
Madam President, can the Honorable Attorney General indicate when would be the earliest opportunity for officials, lawyers, and other search clerks to access manually the searches that they have to engage in for land titles? Could you identify as early as possible?
This opportunity, as I indicated in phases, will start with RPO, Real Property Ordinance titles. We have moved those as of today. We're unpacking it as we speak. I just left the registry. I anticipate in a couple of days' time that RPO manual searches will be permitted. The old law searches, the country books, etc., those will follow in short time after that. I want to take this opportunity to sincerely thank, from the bottom of the hearts of every citizen of Trinidad and Tobago, the Registrar General, the Permanent Secretary of the Ministry of the Attorney General, the hard-working staff that have worked all weekend long, day and nights. Very importantly, the members of the Trinidad and Tobago Defense Force that have turned up in their numbers in disciplined ranks to move millions of documents from one location to another location so far without incident.
Next question, Senator Mark.
Thank you, Madam President. To the Honourable Minister of Rural Development and Local Government. In light of reports of flooding in South Trinidad on September the 16th, 2018, can the Minister inform the Senate of the measures being taken to render assistance to affected residents?
Minister of Rural Development and Local Government.
Thank you very much, Madam President. I want to thank Senator Mark for the question. The Disaster Management Unit of the 14 municipal corporations continue to conduct damage assessments following the inclement weather experienced on Sunday 16th and Monday 17th of September, which occurred as a result of an active intertropical convergence zone. All disaster management units have reported that floodwaters have receded at this time. However, it should be noted that there were more occurrences of street flooding as opposed to flooding in homes of residents in central and south regions. For instance, street flooding occurred in St. Mary's Village, Moruga, and other surrounding areas. In Kuva, Tabaki, Talparo regions, reports of flooding were mainly in roadways and streets. Prior to the adverse weather, sandbags were delivered to many flood-prone households in South Trinidad as a preventative measure. 100 sandbags were distributed in the Pluck Road area of the Siparia Regional Corporation, and 35 sandbags were distributed in low-lying areas of the Chaguanas Borough Corporation. The disaster management units are preparing for referral letters to the families that have been affected so that they may be able to seek assistance to restore lost appliances and furnitures through the appropriate welfare agencies. Thank you very much.
Senator Mark. Oh, next question.
To the Honourable Minister of Health, can the Minister advise what is being done to assist Shanice Jackson?
Minister of Health.
Thank you very much, Madam President. Madam President, I join with the rest of the country in empathizing with Shanice and her parents, and I think we all want a resolution to this very complex, complicated issue. Madam President, the final solution to Shanice's problems lie in the family, a member of a close family, coming forward, volunteering to be a living donor, to donate a part of their liver to this child. I want to make the appeal to those family members. We are not asking for your entire liver. The liver regenerates. We take a portion of your liver, transplant it to Shanice, and both donor and donee will live happily ever after. The problem is the family has yet been unable to come up with a compatible, willing donor. We are making arrangements with hospitals who may be interested in doing an incompatible donor. But those hospitals are loath to take on that extra responsibility. I see in the media ATHE from Argentina is mentioned. They are a broker. The hospital that they use and we use is Hospital Privado. They have done this in the past, but only for compatible donors. And they have indicated they are not willing to take the risk for an incompatible donor. For any South American hospital to do this with an incompatible donor, their domestic laws state that they must have judicial authorization once it is a non-family member coming to South America. That's a further complication. Colombia does not do this type of surgery with incompatible donors. Brazil does not do it. We have gone to the World Pediatric Project to find a hospital. We have gone to the United Kingdom, the United States, Germany, France. We have gone all over the world, and we can't find one for incompatible donors yet. Thank you.
Senator, Honourable Senators, the time for urgent questions has now expired.
Questions on notice. Questions for oral answer.
Leader of Government Business.
Thank you very much, Madam President. Madam President, the government is pleased to announce that it will be answering questions number 180, 181, and 182.
Senator Mark.
Thank you, Madam President. Question number 180 to the Honourable Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, based on the current flood alleviation and monitoring system in the Drainage Division, and at the request of the Member of Parliament for the Martin Northeast, the La Saiva River and Silt Trap in Maraval are cleared on a regular basis and was most recently cleared on August 21st, 2018. This work has alleviated flooding in the area to the extent that there has been no serious events of flooding in the area during the year 2018. Further, the river and silt traps are being monitored consistently as the ministry is aware of the land and building development in the area, causing silt and debris to be deposited frequently. The river and silt trap are scheduled to be cleaned again in November 2018 and will be cleared before, if necessary. I thank you.
Senator Mark.
Madam President, can I ask the Honourable Minister whether there is a time frame for the clearing of this particular river, or is it dependent on circumstances?
Minister.
Yeah, true. Madam President, a couple months ago, the Cabinet approved a budget for the Ministry Drainage Division to increase its capacity on its maintenance of the cleaning of rivers and watercourses. The cleaning of rivers and watercourses is done under our recurrent maintenance program, and there is a schedule for all rivers in Trinidad and Tobago based on the availability of funding. The program continues. Thank you.
Senator Mark.
Can the Honourable Minister share with us the value of that budget that was allocated for the cleaning and cleaning of drains and rivers?
Minister.
Madam President, that budget allocated was $32 million. It entailed 298 projects throughout Trinidad and Tobago, and I'm pleased to announce that the ministry have completed and is in the progress of completing over 260 of those projects. I thank you.
Senator Mark.
Yes, Madam President, could the Honourable Minister indicate whether the $32 million allocated has been exhausted, or do you still have funds remaining?
President, we got an allocation, and based on the releases, we still do have some releases, and we're expecting that those releases will allow the program to continue. However, if the releases are not given on time based on the factor of the budget, the program will continue in the next fiscal year. I thank you.
Yeah. Next question. Senator Mark.
Thank you. Question number 181 to the Honorable Minister of National Security.
Minister of National Security.
Thank you very much, Madam President. Madam President, based on information provided by the Trinidad and Tobago Police Service, on Tuesday, the 15th of May, 2018, a special reserve police officer attached to the Trinidad and Tobago Police Service was questioned by Border Force officers at Gatwick International Airport in the United Kingdom. It was reported that the officer retrieved a suitcase belonging to him from the baggage belt and was asked whether he was aware that it is illegal to import drugs into the United Kingdom, to which he answered yes. Further, the Trinidad and Tobago Police Service has indicated that no official report has been received concerning the officer's arrest in London for possession of cocaine or any other illegal substance. However, this matter is being pursued and investigated with our foreign counterparts.
Senator Mark.
Madam President, is the Minister confirming that a police officer attached to the Trinidad and Tobago Police Service was arrested in London for possession of cocaine?
Senator Mark, you're just re-asking the question. Put your question a little differently.
I asked the Honourable Minister whether the government is pursuing measures to address the recent arrest of a police officer in London on charges of being in possession of cocaine.
All right. Minister of National Security.
Ma'am, with the greatest of respect, Madam President, that is asking the exact same question. At no point in time in my response did I say that any Trinidad and Tobago police officer was arrested in London, according to what my learned colleague has said on the other side.
Can the Minister therefore confirm whether a special reserve police officer was interrogated in London on this matter?
Senator Mark, the original response of the Minister took that into account and set out what happened. So you have one more question, supplementary. Yeah? Next question.
Question number 182 to the Honourable Minister of National Security.
Minister of National Security. Yes.
Thank you very much, Madam President. Madam President, the Commissioner of Prisons has indicated that prisoners are escorted to the courts by the Trinidad and Tobago Police Service and transported by Amalgamated Security Services. Additionally, video footage viewed by the Trinidad and Tobago Prison Service revealed that inmates are searched and placed in handcuffs before being handed over to the TTPS. Furthermore, all inmates are handcuffed and only released when in front of a magistrate prior to entering the docks. The use of leg cuffs on the feet of prisoners are also utilized to assist in controlling inmates' mobility. Police officers are also assigned to supervise inmates when they arrive at court. Furthermore, the Commissioner of Police has indicated that there are well-established protocols and procedures to treat with the escort and security of prisoners. These protocols and procedures are contained in the police standing orders and the police service regulations. Police officers are reminded of the need to perform the duties in very professional manner and in keeping with the rules and regulations governing the security and escort of prisoners. It is regrettable whenever there are occasions of prisoners escaping from custody. And this is something that is being monitored by both the Trinidad and Tobago Police Service, Amalgamated Security Services, and the Trinidad and Tobago Prison Service.
Senator Mark.
Can the Minister indicate, Madam President, in light of all these stringent measures being undertaken as well as protocols, what specific initiatives, apart from monitoring, are being undertaken by the police to avoid this situation where prisoners are still being allowed to secure their freedom in this country? What other measures, apart from monitoring?
Minister.
Thank you very much, Madam President. Madam President, it is regrettable that once again the language being used by Senator Mark is a criticism of the Trinidad and Tobago Police Service. And for him to say that they're being allowed to secure their escape. As I have said, the police service are working with the prison service and amalgamated security services. There is no instance where they are intentionally allowing anyone to escape. And this is not something that is usual, so it should not be sold as though it's something that is usual. And they will continue to work assiduously to ensure that no one escapes.
Senator Ramdeen.
Thank you, Madam President. Madam President, through you to the Honourable Minister. Minister, is there a protocol in place where, when these situations occur, for example, these escapes in the different magistrates' courts, that a report is generated and sent to the Ministry of National Security so that steps could be taken by the Ministry to ensure that these things don't reoccur and whatever has been the shortfall in the system, that it is stamped out?
Minister.
Madam President, it's quite ironic that those in the opposition are now suggesting that the Ministry of National Security should get involved in the securing of prisoners. But when conducting work on other occasions, Ministry of National Security is being criticized as to why it is present. Reports would come to the Ministry of National Security if so requested. The Ministry of National Security at this time is not playing any role in policy governing the escape and the securing of prisoners beyond what exists in the law. As I just said, this is not a usual occurrence. There is no crisis. At this time, there is no need for the Ministry of National Security to intervene in these very, very, very limited circumstances.
That's it? Okay.
Madam President, I'd like to invoke Standing Order 2715 regarding question number 187. Thanks.
Standing Order 27 sub 15 will be invoked in respect of question 187.
Public business, government business, bills second reading.
Honourable Senators, the debate on the second reading of the following bill, which was in progress when the Senate adjourned on Friday, September the 14th, 2018, will be resumed. A bill entitled An Act to Amend the Interpretation Act, Chapter 301, the Supreme Court of Judicature Act, Chapter 401, the Summary Courts Act, Chapter 420, the Bail Act, Chapter 460, the Administration of Justice Deoxyribonucleic Acid Act, Chapter 534, the Legal Aid and Advice Act, Chapter 707, the Child Rehabilitation Center Act, Chapter 1305, the Indictable Offences Preliminary Inquiry Act, Chapter 1201, the Children Act, Chapter 4601, the Children's Community Residences, Foster Care and Nurseries Act, Chapter 4604, the Children's Authority Act, Chapter 4610, and the Family and Children Division Act 2016. Those who have spoken on this bill are as follows: the Honourable Attorney General, who moved the motion, Senator Gerard Ramdeen, Senator Elton Prescott, SC, Senator the Honorable Jennifer Batiste Primus, Senator Khadija Amin, Senator Paul Richards, Senator Pastor Clive Dottin, Senator Garvin Simonet, Senator Anita Haynes. Senator Choot.
Thank you very much, Madam President, for the opportunity to make my contribution to this bill. There is just one aspect of this bill that concerns me. I think the other aspects of the bill, which deal with the regulations of the authorities which govern children's homes and so on, I can say that those matters have been adequately addressed by speakers before me, in particular Senator Amin and Senator Richards. So I will confine my contribution to that proposed amendment of the Supreme Court of Judicature Act, which purports to do two things. One, it purports to increase the number of judges, and two, it purports to permit any member of the bar of any Commonwealth country to become a judge of the Supreme Court of Trinidad and Tobago. Now, I have heard some of the concerns initially raised by Senator Prescott when he spoke on this matter, but I do have some additional points to make. Now, let me start by building blocks, using blocks to build my argument. In 2017, when Justice of Appeal Jamada was giving the speech to honor Dr. the Honorable Lloyd Barnett at the Hilton Conference Center on the 7th of September 2017, I think he put it very succinctly. He said, judges were first lawyers and both were once law students. Now, this legislation essentially creates a sort of odd situation, because what it does is that it says that not every person from a Commonwealth country may practice at the bar of Trinidad and Tobago unless you follow certain procedures and you get the accreditation of a Caribbean law school. But this legislation purports to say that any citizen of a Commonwealth country or any member of the bar of a Commonwealth country may sit as a judge. So it means that you can't practice as an attorney unless you are accredited by a Caribbean institution, but you can sit as a judge of the Supreme Court. And something about that simply doesn't make sense to me. So I decided to look at the topic a little more deeply. And when Senator Simonet made his contribution, he had mentioned in particular, I believe, Justice Telford Georges and his contribution, Sir Hugh Wooding, and so on. So I looked back to see what these legal luminaries had said about our Caribbean education and our system of justice. I didn't have to look too far, because when the judiciary celebrated 50 years of an independent court of appeal in Trinidad and Tobago, there was a document prepared by historian Bridget Berreton. And in that document, which is on the website, there's a reference to a speech given by Sir Hugh Wooding in 1966. This is just after independence, where he said, what we wanted on the bench were lawyers who belonged. Because we, as a colonial society, had gone through centuries of having persons sitting as judges who were not part of the society of Trinidad first, and then Trinidad and Tobago. So Sir Hugh Wooding said, we wanted, as an independent nation, we wanted on the bench lawyers who belonged. And he went on to say, lawyers who understood our people, our ways of speaking, and our habits of thought. Lawyers who knew and could comprehend our emotions and motivations. It was frustrating to cross-examine a witness and get an answer which had subtle overtones which were lost upon the ear of the presiding judge. He proudly noted in 1966 that all the judges were West Indian. And I think philosophically, that is why we have been able to build a Caribbean jurisprudence. And to a large extent, we've been able to meld strong ties amongst our bar associations and amongst the judges of the Caribbean to create a Caribbean jurisprudence, which eventually led to the creation of the Caribbean Court of Justice. So we have developed legally and in terms of the justice that we offer to our citizens in the Caribbean in a certain way. I start with that. Justice Jamada, in the same speech to which I had referred, said that what we need to do is to ensure the Caribbeanization of legal education, which must include specific and coherent skills-based training that incorporates the historical, social, political, economic, and cultural lived experiences of our peoples in the reading, interpretation, and application of the law. Now, I know I am perhaps sounding a little esoteric, but to some extent, this is a philosophical point that I'm taking, which pertains to our sovereignty as a nation and our independence as a bar and our independence as a judiciary. Now, what Justice of Appeal Jamada had to say, really, after several decades, was something which had formed the basis of considerable deliberation since the 1960s and resulted in the opening of 2 law schools in the Caribbean, the Hugh Wooding Law School and the Norman Manley Law School. I believe it was in 1970. It was a recognition by the leaders of Caribbean nations, or I suppose how I should put it now, the Anglophone Caribbean nations, that we needed to have a legal education system of our own to reflect the identity of our Caribbean peoples. And of course, that meant that those attorneys who were so qualified would then become the judges who would adjudicate on cases with the social and cultural sensitivity which was expected of them. So there was an agreement establishing what we now know as the Council of Legal Education. And I think we need to remind ourselves of what the contracting parties agreed to. I'm referring to the actual agreement establishing the Council of Legal Education. And it says the contracting parties, sharing a common determination to establish without delay a scheme for legal education and training that is suited to the needs of the Caribbean, aware that the objectives of such a scheme of education and training should be to provide teaching in legal skills and techniques, as well as to pay due regard to the impact of law as an instrument of orderly social economic change, convinced that such a scheme of education and training can best be achieved by, firstly, a university course of academic training and so on. But it continues, the training must be designed to give not only a background of general legal principles and techniques, but an appreciation, and I emphasize these words, of relevant social science subjects including Caribbean history and contemporary Caribbean affairs. So since 1970, we have been producing attorneys at law, and as a result, judges who have gone through this system one way or the other, whether they entered the law school via the UWI, the Faculty of Law, or whether they did their degrees abroad and had the conversion courses done at one of the law schools. The fact is, their legal education was required by this agreement to be streamlined to suit the needs of the people of the Caribbean, of the Anglophone Caribbean. Now, what we are doing here is we are blowing the door wide open. We're not just opening it slightly. We are blowing the door wide open to any member of the bar of a Commonwealth country to not practice in Trinidad and Tobago, you know, but to jump ahead of the practitioners in Trinidad and Tobago and to sit and adjudicate as a judge of the Supreme Court. Now, to me, it is true that I am not as young as I used to be, but there are young attorneys who on their career path look forward to achievements. You don't qualify as a lawyer and you say, okay, I'm going to be a lawyer for the rest of my life. Many of them aspire one day to become a judge of the Supreme Court, and when they become a judge, they aspire to go further to the Court of Appeal. So we are saying to our young practitioners who have gone to the trouble of making sure that they have obtained a legal education which is suitable for our nation, we are saying to them, well, when it comes to the judiciary, you're now going to have to compete with people who didn't have to go through that process. Now, I think that is grossly unfair. Even if there is some sort of examination or testing process, I think it is grossly unfair that having set up a system of legal education along the lines of what was decided since we became an independent nation, to permit that our courts be filled by persons educated with our cultural and social sensitivities, to now say, so many, 50-something years later, I don't know if my maths is right, but 50-something years later, to say that we are going to have this big change in who will adjudicate. Now, I would like to make the point. Something struck me as other presentations were being made. Senator Simonet, when he spoke, out of all the Commonwealth nations that there are, and even if we look at the ones only referred to in the Constitution, out of all the Commonwealth nations, chose to refer to Ghana and Nigeria as being potential sources for justices of the Supreme Court of Trinidad and Tobago. And the Honorable Attorney General, in a not so sotto voce comment during the contribution of one of the senators, referred to financial crimes. So perhaps I'm being a bit of a Nancy Drew in this, but if it is that it is being contemplated that two Commonwealth jurisdictions have been identified as potential sources for judges of the Supreme Court, I think in all fairness, we need to look at whether their jurisprudential development is in line with ours. I think that I will have to say that they are not, because starting with their independence, they are in the same position as India and Pakistan, for the same reason that a judge, with all due respect, or a practitioner from India or Pakistan would not be a good fit for our country. I respectfully say the same thing is true for someone from Ghana or Nigeria. And the reason is this. What happened is when many Commonwealth countries got their independence, there was some talk of wanting to have a sort of regional Commonwealth court. That was immediately set aside because it was recognized that people from within the Commonwealth had so many diverse backgrounds for various reasons. Some people, some Commonwealth nations, decided to stick with the Judicial Committee of the Privy Council, as we in the Anglophone Caribbean did. A few countries, India, Pakistan, Ghana, and Nigeria being 4 out of 6, I think, decided that they, and Guyana, if I may add that in, they decided that they were not going to have the Privy Council as their highest court of appeal. So their jurisprudence developed in a manner which was unique to them. And unlike our highest court, the Privy Council, because when it sits on an appeal from Trinidad and Tobago, it treats itself as the highest court for Trinidad and Tobago. And if it sits on an appeal from Barbados, it treats itself as the highest court of appeal for Barbados. But what happens is the Privy Council tends to maintain a commonality of jurisprudence or jurisprudential ideas, because our Caribbean constitutions are not that different to begin with. And secondly, also because much of the legislation which we have or which we've developed, they've come from England. And we've developed more or less at the same pace as we go along because of the tightness of the attorneys practicing within the Caribbean and the judiciary practicing within the Caribbean. So there is immediately, I would say, how should I put it? There is a disparity between the jurisprudential knowledge, let us say, of someone who has practiced at the bar in Ghana, Nigeria, India, Pakistan, and Guyana from an attorney who has come through our system and has practiced in our court and has practiced in Caribbean jurisdictions. Now, I feel as though I may be speaking to deaf ears, but I think it is absolutely crucial for me to make this point in defense of our bar, in defense of our independence as a bar in this country. Now, I went further to see, well, and I only used those 2 examples because of what Senator Simonet said. Otherwise, I hadn't really looked at the issue of which Commonwealth countries might make or produce judges which would be a good fit for us in Trinidad and Tobago. So in a sense, I have to be grateful to Senator Simonet because he sort of made my job a bit easier by directing me as to how my research on this matter could go. Now, the other point that I want to make is this. When the Council of Legal Education was formed, things went along fairly well until around the 1990s when people wanted to change the method by which persons were admitted to the bar in Trinidad and Tobago. Trinidad and Tobago got itself into some trouble because it amended the Legal Profession Act to allow for certain persons to be admitted to the bar of Trinidad and Tobago, contrary to the agreement which set up the Council of Legal Education. And the reason Trinidad and Tobago said that it had done that was because it said that so many people were becoming lawyers and there were not enough spaces at the law school to accommodate them and so on. So they had to amend the law. Well, that is gone. but we have seen the impact of that. One of the good things, though, that came out of that was Dr. Barnett, who, as we know, is a legend in the law. He's a constitutional law icon, among other things. He's a legal education icon, among other things. He was tasked to chair a review committee which produced a report in 1996, which was called Report of the Review Committee on Legal Education in the Caribbean. Now, this is 1996, and by this time, the law schools had been set up for a considerable period of time. So the significance of this report is to give us an indication of whether, contrary to what I'm saying, that the legal educators in the Caribbean and the judges and so on were starting to think or rethink the philosophical position which had informed legal education in the 1960s. But what I realized is that was not the case. Dr. Barnett was making it quite clear that our Caribbean legal education was something that we needed to protect, we needed to develop, and in fact, the report chastised the government of Trinidad and Tobago at the time for passing legislation of that kind. And Dr. Barnett, in his report, referred to that portion of the agreement to which I had referred to earlier in my contribution. But during the course of the report, when he was speaking about alternative solutions to deal with the issues not only of increasing numbers of persons seeking admission to the bar, but also there was a difficult situation with respect to the Bahamas and also with respect to the quality of the degree being offered by the University of Guyana. So this is what the report said. At paragraph 312, we are convinced that the Faculty of Law of the University of the West Indies and the Council's law schools have, in a relatively short time, made considerable progress towards the attainment of these ideals and objectives. We are concerned that some of the recent developments and proposals threaten to undermine the foundations which have been so well established and to retard further progress. We are opposed to unrestricted admission of non-nationals to the bars of the Caribbean countries or to nationals being given a means of circumventing the essential requirements of our system by obtaining legal training and legal education and training provided by other agencies within or without the region. And I don't think it could have been put better than that. And this was signed, Dr. Barnett was the chairman, it was signed by, I think it was our then Attorney General, Mr. Keith Sobian, the late Mr. Keith Sobian, Andrew Burgess, Austin Davis, who at the time had been the principal of the Hugh Wooding Law School, Maurice King, QC, Christopher Blackman, QC, Philip Davis, and William Roper. And those names should give you an indication of the strength of the committee and the strength of the intellectual contributions made by those persons. So I'll take it a little further. If we are looking at persons outside of the Anglophone Caribbean, and we are saying that members of the bar may be admitted to the bench, let us go through it by stages, and let us see whether a member of the bar from a country such as Ghana or Nigeria may be admitted to the bar here without more? The answer is no. When you look at the agreement of the Council for Legal Education, first of all, there are only 3 universities from those territories which provide an acceptable or an equally good degree as the University of the West Indies. There are 3 universities identified. And if someone from those universities, a graduate of those universities, wants to be admitted to the bar here, in addition to going through our law schools, what they must do is they must do courses in constitutional law and legal systems. So it means to say that requirement by itself, Madam President, means that the degrees offered in those universities to those students do not provide them with the grounding in constitutional law and legal systems which you need to practice at the bar here and ultimately to become a judge if you do well. Now, how can you be unfamiliar with these 2 subjects? Because these 2 subjects form the basis of all law and practice. And I suspect, now don't get me wrong, I know that there are people listening out there who will say, oh, Chot, it must be an ethnic reason that she's referring to Ghana and Nigeria. I know that there are small-minded people out there who would think that. So just to deal with anybody who might be thinking so, anybody coming from Canada also has the same problem. They also have to be certified that they know about our constitutional law and our law and legal system. And I'm talking about the top Canadian law schools. We're talking about McGill. We're talking about Osgoode Hall, and so on. So it is not to say that I am suggesting that only countries from a certain part of the world ought not to be eligible to have their citizens come here to sit as members of our Supreme Court. But what I'm saying is that there is a good reason for that not to happen. Now, when I did my research even further, something struck me. Before we took the break, I remember we were dealing with a particular piece of legislation which referred to special offenses. And as a criminal practitioner, I thought to myself, what are special offenses? And I believe I may have even asked the Honorable Attorney General at some stage what that meant. And I don't think that it was categorized further. But in my research, you know what I found? Again, like Nancy Drew, I found that in Nigeria, a special court has been set up to deal with special offenses. And those courts deal with financial crimes, which the Honorable Attorney General had spoken about, not so sort of voce, and sexual offenses, because apparently sexual offenses are a big problem in Nigeria, and there was a huge backlog in sexual offenses cases and financial crimes cases. So essentially, if I put this all together, I think the purpose of this proposed amendment is to draw upon the experiences perhaps of Ghana and Nigeria in dealing with financial crimes and possibly sexual offenses. For the reasons that I have identified earlier, I would respectfully submit that I cannot support this legislation for all that I have said before. Now, sure.
If I could just categorically say at this point, because it may affect your thinking, the experience in Nigeria and Ghana has never once come into the contemplation of the executive in any form or fashion at all. So I noticed you spent quite a lot of time, and you explained why from a Commonwealth perspective, but I just wanted to make that absolutely clear in case it affected some of your contribution. Thank you.
No, thank you, Attorney General, but I think I made it quite clear that the only reason I referred to these two countries as examples is because they were identified by Senator Simonet. So I don't know that anybody, I don't know if this was just two examples picked up by Senator Simonet, but because he used those two examples, I thought, why not? Out of all of the Commonwealth countries.
That's what George is.
Yes. Again, the Honorable Attorney General, not so sotto voce, speaks about our nationals who went there, but the Honorable Telford Georges, I believe, had gone to Zimbabwe and Tanzania. So if it is that, the point I'm making is that not only is it a bad idea because we've developed our own unique Caribbean jurisprudence and our own unique Caribbean legal and judicial ties, which have pushed us towards the creation of a Caribbean Court of Justice, which I hope that we at some point might be able to accede to. But it seems as though we are taking a step back because now we are bringing in people who are not qualified in the way in which we want them to be. We are not saying that you have to even have practice at the bar here. We're saying, here what? Can you come in and you go straight to the Supreme Court of Judicature? What does that say to Caribbean practitioners? Quite frankly, I think that is an insult, with all due respect, especially when we look at who we have on the bench here. We have on the bench here judges who have held the office of acting DPP or DPP in other jurisdictions. They have prosecuted financial crimes. They have given directions for financial crimes to be prosecuted. In addition to that, since about 2001, we have had members of the private bar engaged in the prosecution and defense of financial crimes. We are here 17 years later. Off the top of my head, I can think of at least 10 people who might be considered if there were a need for judges to deal with financial crimes. Some of them are already sitting on the bench. So it is simply a matter of assigning those cases to them. I don't like it when, as a parliament, we come and we make as if we don't have the quality and we don't have the depth of learning and knowledge to do things which we have been doing for many years. Now, I agree that very often practitioners from the United Kingdom, at all levels, they come and they practice in Trinidad and Tobago. But they are only able to do so if they are able to obtain a certificate from the Attorney General which allows them to practice at the bar. And that certificate is not just for one occasion. It's not just across the board. Usually it is for a case. So you are permitted to use that process to come and do a case if you are a practitioner in a foreign country. It doesn't mean to say that you could go and sit as a judge. Even the most eminent QCs don't have that liberty because they have not gone through the Council of Legal Education requirements. So a special process had to be put in place for them to be able to come here to do cases. So I would respectfully suggest that this is not
Senator Choate, you have 5 more minutes.
Thank you very much. This is not something as easy as increasing the numbers of judges. If that was so, I would say yes. I know the judges don't have the resources and so on, but I'm hoping that one day, you know, we will have extra judges and we will have extra place to put them and so on. So that's not my problem. My problem is that we are creating an unequal system. We are creating a system which is going to foster inequity between our own people, our own citizens, our own attorneys at law, and their capacity to ambitiously look towards one day sitting as a member of the Supreme Court. And we are treating them with less generosity than we are treating common citizens of Commonwealth countries who have simply been admitted to the bar in their countries, regardless of which university they came through. So, Madam President, I don't want to go on too much about it, but I will end on a note of levity, because, or at least what I think is levity, we had the experience of an English judge sitting as an acting judge here. And he was never confirmed, and he acted on 2 occasions, but the whole situation became very replete with contention. And it was because the judge did not appreciate the language that the practitioners were using in court. The judge was not sensitive to the players in the courtroom. The judge pontificated about, well, in England we do this and we do that, seeking to humiliate our practitioners with respect to things which we had learned. It became so bad that a young woman was cross-examining a witness who was from Chaguanas, who was talking about a wounding. And she says, oh, so you sat on the pier, huh? And you say that you saw this. Now, in rural communities, a pier is just a low stool that you sit on to shell corn and husk rice and that kind of thing. The witness had to be spoken to in that manner because that is the kind of language she understood. And counsel was asking quite properly the witness a question in the language she understood. The judge took grave offense to this. And counsel is trying to explain, well, if I ask her if she was sitting on a low stool, she'll have no idea what I'm talking about. And it came to a very unpleasant end where the attorney was chastised for not speaking the Queen's English in Trinidad and Tobago, independence since 1962, but also for not using a phrase to be found in Kotsi Kotla. And I hope that that by itself demonstrates how absurd this can easily get. And I am speaking about an actual experience which we had in this jurisdiction. So, Madam President, I thank you for the opportunity to contribute.
Senator Hussain.
Thank you very much, Madam President, and I will also like to join in welcoming you back to this honorable House. Madam President, before us, we have the Miscellaneous Provisions, Supreme Court of Judicature and Children Bill 2018. And this bill seeks to amend 13 pieces of legislation in an omnibus bill. And most of the bills that are contained within, most of the laws that are contained within this bill, Madam President, touch and concern the criminal justice system in Trinidad and Tobago. And when I read the bill, it sought in an attempt to address some of the issues that currently plague the current situation of the criminal justice system. And if you would allow me to quote Madam President, just to give a context of my presentation, from the first report of the Joint Select Committee on Finance and Legal Affairs on an inquiry into the criminal case flow management in the judicial system, at page 13, Attorney at Law Trevor Sinanan, in a submission to the committee, said, "The large number of cases before the courts every day is a reflection of the very high level of criminality in society. Society is plagued with delinquency and disregard for the rule of law, as evidenced by the level of violence in certain secondary schools." And Madam President, when I look at this bill, I wonder whether or not this bill will be able to adequately address even one of those issues facing the criminal justice system. What we have to do, Madam President, is address the root causes of criminality and crime in Trinidad and Tobago. Because if we fail, and if the government fails to address the current crime situation, the courts are only going to be more and more filled with matters before it to adjudicate on. And there will be an endless backlog. And Madam President, this year is one drop in the bucket. What the bill sought to do, as Senator Choate would have indicated, is that it now increased the number of judges and also increased the pool of judges from which the JLSC, which is a constitutional body, would be selecting judges for appointment by Her Excellency. And we are going to now increase the number of judges, but populate our judiciary with foreign judges. And Senator Choate would have raised several issues regarding the foreign judges. Now, I don't wish to go into all of the issues that Senator Choate would have mentioned, but I will attempt to raise my own issues, Madam President. And while I agree that it's noble that if we appoint more judges, that we can actually see some more production within the criminal assizes and the judiciary, we must be cognizant of the current state of the judiciary as it stands. And the Attorney General will continuously bring legislation to this Parliament on a piecemeal basis, that we amend certain pieces of legislation as we go along. But Madam President, had we not all sat around the same table and joined our voices so that we can have a map, we can all have one solid policy on how we are going to address the criminal justice system, so that when we come to the Parliament, we will know that these are the building blocks that we need to include, or these are the pieces that we need to include, or the fixes that we need to make in order for the criminal justice system to run smoothly. But what we are doing is amending laws in a piecemeal basis, and I think that is very counterproductive. But recently, in this very Parliament, the Family and Children Division Bill was passed, now an Act of Parliament. And in Schedule 5 of that, we saw the Supreme Court of Judicature Act was in fact amended. So in 2016, this exact provision that we are amending today was already amended to move the number of judges from 36 to 49. And today, we are amending the legislation to move it from now 49 to 64. 15 more judges we are going to be including in our judiciary. And when we look at the current state of the backlog, and I had the benefit of reading the 2017-2018 annual report of judiciary, and I would like to read into the record what the backlog is currently according to that report. At the Port of Spain Court Registry, cases, there are 459 cases currently at that criminal registry. At the San Fernando Assizes, there are 236. At the Tobago Assizes, there are 14. The number of courts in Port of Spain are 6 assizes. In San Fernando, there are 3, and in Tobago, there are 1. And Madam President, this is wholly inadequate in order to address the criminal case flow that comes within the judiciary every single year. Because on one hand, you have more cases coming, and on the other hand, you have less cases being dealt with and adjudicated upon. When we look at the current state of the Director of Public Prosecution's Office, in that case, according to the JSC report that I quoted from earlier, it indicated that the average workload of prosecutors at the Port of Spain Assizes are 66 matters in 2010. This is per prosecutor, 78 matters in 2012, 84 matters in 2014, and 150 matters in 2016. And you expect these prosecutors to now come, we're going to establish more courts, more judges, but the Director of Public Prosecution's Office is clearly inadequate to deal with the situation. And there's a severe human resource deficit currently at the Director's Office. And I think in order for us to move the wheels of the criminal justice system forward, we should also address these issues. We can't just simply come to this Parliament and say that we are going to increase the number of judges and that will assist. Madam President. Now, another interesting point that Senator Ramdeen would have dealt with also was that of the appointment of judges. And this has been a very contentious issue in this country, Madam President. And if there's so much to say and so much contention by members of the public regarding the appointment of judges, then what confidence does the regular man on the street who places their confidence in this independent judicial system to protect their rights, their privileges, and their freedoms will have in the judiciary if there are so many internal problems within that institution? And the Law Association compiled a report, this report on the Committee on Judicial Appointments, June 2018, Madam President. And according to the Constitution of Trinidad and Tobago, Section 105 of the Constitution indicates the criteria and the qualifications in which a person shall have with regards to be, when read with the Supreme Court of Judicature Act, for being appointed as a judge in Trinidad and Tobago. And judges of the High Court, they are appointed by, they are interviewed, they are selected by the Judicial Legal Service Commission, who would then recommend to the President, Her Excellency, the persons who they would like to be appointed as judges. Now, in this same report, Madam President, they spoke of the history of judicial appointments. And the reason I'm raising this point is that if we are going to increase the complement of judges, we must get the process in which these judges are appointed right first. And the pre-2000 position would have been that you tap someone on the shoulder and give them the indication, well, you can apply to be a judge. Then it developed after 2000 with more transparency with regards to public advertisement in terms of persons who are appointing judges. Then there's a post-2009 position, Madam President, which currently exists, where a person who is to be selected as a judge will apply through after public advertisement in the newspapers. But according to the report, Madam President, it says this at page 26. The actual process of selecting persons to be offered judgeship is opaque. Based on the submissions of recent applicants, the JLSC conducted an interview with applicants, which may last about 1 hour, and which touches on their previous legal practice experience, awareness of current developments in the judiciary, work habits and interests. And when you look at the appointment of these persons, it indicated that these persons on assuming duty, there's no proper protocol with respect to their orientation, with respect to their appointments. And if we are going to include foreign judges...
Senator Hussain, may I ask you, are you referring to a report and all your commentary is based in that report, or are you referring to the report and then you're adding your commentary? In other words, when you're talking about the report, I want you to just be specific if you're quoting from the report. Okay?
Thank you very much, Madam President. My earlier comments was based on a quote, and I would now give my commentary on what I have quoted, Madam President. If I was not clear, I apologize to you. And Madam President, the point that I was making is that from the report is that currently the selection process for judges is quite unclear. And the report gave some guidelines to the Chief Justice, to the JLSE, who is the chairman of the JLSE, in terms of some of the observations that they would have from this report. And Madam President, it shocked me to know that there is no documented job description for a High Court judge in Trinidad and Tobago. So it really leaves a very subjective test or a subjective criteria within the JLSE in order to appoint someone as a judge. One other observation that was made is that not many persons who sat as magistrates were able to elevate themselves to a judgeship. And there are a lot to say about this, Madam President, but this matter is before court. Also, there are issues with respect to confidentiality in terms of some of the practitioners are complaining that their information is finding its way into the public domain after an interview with the Judicial and Legal Service Commission. And these are all issues, Madam President, that we must be cognizant of. Because which senior practitioner would want to subject themselves to this interview, and then the next day on the newspaper, you hear that, for example, if Senator Truth would allow me, that Senator Truth applies to be a judge. Now, this will cause some sort of embarrassment if this practitioner is not, in fact, selected to be a judge. And there must be strict confidentiality with respect to the selection and appointment of judges in this country. And that brings a very important point, Madam President, is that I don't know how transparent or how accountable this JLSE process is. Because recently there's an article from the Saturday Express, 29th April 2017. And this was an interview with Senior Counsel Martin Daly. And he said that the Chief Justice is wrong to tout his successor. And Madam President, if you would allow me to quote from this article, it says, Daly also took issue with the Chief Justice's statement on another matter. And he quotes, "This is also an appropriate occasion to ask how could the chairman of the commission tout someone, however meritorious that candidate might be, as a future Chief Justice, as was recently reported as done on a social occasion. No candidate for judicial office should be perceived to have inside track with the commission or with persons in a position lobby the President of the Republic in respect of any appointment of a Chief Justice that he might be called upon to make after appropriate consultations." And Madam President, the article goes on to say, speaking at a function on April 13th at Queen's Hall, St. Anne's Archie, and paying tribute to Industrial Court President Deborah Thomas Felix stated, "She has all these first. I am getting a little nervous. It may be there is a first female Chief Justice, and if it ever happens, I will be willing to give more than proxy to Debbie. Debbie has become an outstanding president. She is way too bright. She has gone to the United Nations Appeal Tribunal."
I encourage you to make short, you refer to something, you don't have to read an entire article to make your point, okay? So try and abbreviate some of the references, okay?
Madam President, I do apologize. The only reason I quoted extensively is because, yes.
I don't, Senator Hussain, please. I don't need an explanation. I'm just giving you some guidance and as you proceed with your presentation.
I appreciate your guidance, please, Madam President. And is that I'm a very young practitioner and I would not like to misquote any senior counsel, so I would like to read verbatim from what a senior counsel will have to say, Madam President. And one other startling issue or concern that came out from this report was that the committee found that the JLSC does not consult with other judges or senior practitioners with respect to the appointment of judges, but rather they defer to the Director of Administration, Director of Personal Administration. I apologize. Madam President, these persons are not as qualified or may not be as competent in order to make solid recommendations with respect to the appointment and selection of judges. And this report, the Chief Justice, yesterday at his opening address to the law term 2018-2019, would have given his own remarks with regards to his position on this report, Madam President. And I would not go on to what the Chief Justice would have said. But all I would like to say, Madam President, is that we cannot support this process right now in terms of appointing 15 new judges without the appointment system or the selection criteria being properly transparent, being accountable, and being fair, Madam President. Because there are several practitioners whom I know myself, Madam President. I may not be qualified to say that they are competent to be judges, but there are others who have that view. And Madam President, on application to be a judge, they were all turned down without any explanation given or any feedback in terms of why they were turned down. Madam President, imagine that the JLSC requires senior practitioners, be it of the lower bar and also senior counsel, Madam President, to subject themselves to a written examination. You require senior counsels to go and write a law school exam, Madam President, in order to be a judge in this country? Is it that is why we are going to bring foreign judges, because they are willing to subject themselves to writing an exam, Madam President? Is this the reason for this legislation? When you look at the condition of the judiciary, there's complaints about lack of resources, photocopying, stationery. Some have to buy their own tea and coffee in the judiciary, Madam President. These establishment of all these new courts, the judicial support officers, they are taken away from the Hall of Justice and they are placed in all of these other courts, and they are not replacing JSOs in the Hall of Justice. Secretaries, and yet you expect court to run as normal? Imagine you have a former Chief Justice Clinton Bernard, having to go in a public forum and cry for his pension, Madam President. Is this country in a sufficient position financially to hire 15 judges? And when those judges retire, to pay their pension, Madam President? Because if over 5,000 persons can be fired in this country, and you have the chairman of Petrotrin bawling all, then, Madam President, what does this say? Madam President, you have a minister of government who is saying that he wants a pay increase. Madam President, yet so many are losing their lives and their jobs in this country.
Senator Hussain, I'm not sure where you are going with this argument in respect of the matter at hand. Okay?
Yes, Madam President. And the point I'm making is that when there are so many unemployed persons in this country, you know what goes up? The crime rate, Madam President. And when the crime
Senator
rate...
Hussain, please take your seat. I was trying to tell you in a subtle way that you were now going into some irrelevance. And now you are continuing on that path. So I will ask you now, not so subtly, to please be relevant to the matter at hand.
Madam President, it will only escalate the current state of the judicial system with respect to backlogs in this country. While I accept that we need more judges to deal with them, where are we going to put these judges? Are there any plans currently afoot in order to house these judges? Because currently the Hall of Justice, there are 6 assizes. The San Fernando High Court has 3 assizes that works on a shift basis with the magistrate court next door. I even read an article where the mayor of San Fernando, a PNM mayor, wants to sue the judiciary because of the condition of the magistrate court. Madam President, how are you going to how are you really going to address the criminal justice system? By putting these judges here, and they have no way to go. And Senator Ramdin is right, because I remember an article also last week, I believe, in a daily papers, where the Princestown Court was being heard at the Rio Claro police station. Imagine that. That is an embarrassment to our judiciary in this country. After 56 years of independence, we are now having a magistrate court being held in a police station, Madam President. That is totally unacceptable in this country. And when we look at the other point that this bill is trying to address, which is the opening up the pool of candidates with respect to judgeship, I want to ask the Attorney General, was a study done to determine whether or not we need to do this? Who made this recommendation? Why 15? Why not more? Why not less? Are there already 15 who will benefit from this amendment? Is there any study to show the unsuitability of local persons? When advertisements go out for judgeship, is there a lack of applications, Madam President? Has the JLSC reported that they're having problems finding unsuitable candidates for the bench? Because as I said earlier on, Madam President, there are floods of application for persons who would like to be selected as judges. And Trinidad and Tobago, we are one of the foremost jurisdictions in the Commonwealth in terms of litigating matters in public law, in constitutional law, commercial law, and family law. Other countries, Madam President, borrow from our jurisprudence. Others, Madam President, we in Trinidad and Tobago, we are pioneers in some of the issues with regard to litigation in this country. And all of these matters have been decided by local judges. And I would like to know whether or not if there was any concerns with the Criminal Bar Association with regard to these local judges. Because these 15 judges, Madam President, they are not going to decide on relief from sanctions or payment into court or any claims, Madam President. They are coming here to decide criminal matters. Those 15 judges are coming to address criminal matters in this country. And I want to know who has requested this change. Because the Law Association, in their comments, Madam President, they indicated that they have significant reservation with respect to including foreign judges in our local courts. And Senator Choate hit the nail on the head, that these judges will not at all be able to understand our local circumstances. And I don't know if this was really a well thought out policy by this government, because we cannot support this. And Madam President, the other issue that comes up is that one of these criminal matters that these judges will sit upon. There will be a jury. And in capital cases, there will be 12 ordinary members of Trinidad and Tobago. And in non-capital matters, 9 members, Madam President. And in a criminal trial, for those who are listening outside of this chamber, there's a judge and a jury. The judge is the arbiter of the law. The jury is the arbiter of the facts. But at the end of the criminal trial, this judge now has to speak to these 12 ordinary men and women. And they have to sum up this case to them, Madam President. And will this judge, foreign judge, be able to sufficiently communicate with his jury in order to properly sum up this case so that they can understand the application of the law to the facts? And the answer to that, Madam President, has to be no. Because when somebody, let's just say, for example, there's an issue, let's say there's a fight or a stabbing close to a standpipe. Do you think a judge from England or a judge from Canada or one from Nigeria will understand what a standpipe is? Madam President, these are local things, local circumstances that one has to take into account when making these recommendations. Judges need to understand how the society operates, because they are not making laws, they're deciding on cases in a local circumstance, Madam President. And that is a very important point, because recently in this Parliament, a judge alone bill was passed. Yeah. And then you have another trend of special offenses and special courts being set up under the Criminal Division Bill. So what does that leave room for, Madam President? And we have a very opaque selection process of judges. Now, this can clearly undermine the independence of a judiciary and target certain persons in the society. And we cannot allow this, because there's a trend developing in the types of legislation that this government is bringing to this Parliament. But I would like to quote, Madam President, from the Chief Justice, because I don't know if he supports whether or not there should be local judges or foreign judges in Trinidad and Tobago. And this was an address by the Honorable Chief Justice at the 2010-2011 opening of the law term. And he says, Madam President, if you would allow me to quote, it's a very short quotation. After 48 years of supposed independence, it astonishes me that there's even a debate about whether the CCJ should be our final appellate court. If we have the moral and intellectual capacity to run our own countries in the region, why can we not judge ourselves? This region has produced many intellectual giants, including world-class legal luminaries who sit on international courts. So the notion that somehow we will receive a superior form of justice from London bespeaks a self-doubt and an unwillingness to take responsibility for our jurisprudential self-determination. So I don't know, Madam President, if the judiciary, if the Chief Justice, if the JLSC was in fact properly consulted before this bill was laid in this honorable Parliament. Because it seems that the Chief Justice agrees that we should judge ourselves, because it clearly determines our jurisprudential self-determination. Madam President, I'm being disturbed.
We are supporting that at all. Never.
Thank you very much. Thank you.
Go bring it.
All right.
Sorry.
No, well, you know, members, please let us listen to Senator Hussain. Those who do not want to listen to him, you have the option of leaving the chamber. Senator Hussain, please continue.
Madam President, how much time I have again before I end?
Until 19 minutes past 3.
Thank you. Madam President, with regards to how the local, let's look at the Privy Council and what they think of our local jurisprudence. There's a case of Terence Calix against the Attorney General of Trinidad and Tobago. And Madam President, the Privy Council said that, you know what they did? They reverted that case to the local Court of Appeal, because they said that we are the better body in order to determine that matter. Now, I don't want to quote, again, very extensively, Madam President, but this was also in another case of Privy Council Appeal number 17 of 2010, Ian Sipasad and Rudolph Pancho against the Attorney General of Trinidad and Tobago. And Madam President, all of these cases were remitted to our local courts simply because our local courts were more competent and they knew the local circumstances in order to properly adjudicate and determine our cases, Madam President. And these are some of the issues in which we have to address. Now, when these foreign judges sit in our local courts to determine my rights and your freedoms and your privileges, Madam President, are we truly being independent, or are we going back to a state of pre-independence? And we must also examine what confidence the bar will have in these judges and the confidence that the bench, their own colleagues, will have in them, Madam President. And these are all issues, Madam President, that raise so many concerns with regards to the population, the bar, on whether or not we should actually employ foreign judges in our jurisdiction. And one person I did not hear, one body of people I did not hear the Attorney General indicate that he consulted with was the public on this matter. Because the public is the end user, is the user of the judiciary, is not the lawyers. We simply facilitate the matters into court. But as the general man on the street is the one who will be using the courts in order for protection from some deviance of their rights or their freedoms, Madam President. So I wonder whether or not the Attorney General has in fact consulted with the public, because I believe that such a drastic move requires the public's input.
Definitely. Don't consult at all.
And this, again, is a piecemeal basis in which legislation is continuously brought into this Parliament. But the bill also, Madam President, addresses another concern, and that concern is that of children. And Senator Amin and I believe one other senator raised the issue of why it is the Commissioner of Prisons who are in charge of these rehabilitation centers. And Madam President, we must examine the children that we are placing in these centers. There are two types of children who exhibit juvenile delinquency behavior. Those are life course persistent offenders and adolescent limited offenders. And the life course persistent offenders, Madam President, are persons who are inherited or acquired some neuropsychological deficit leading to an antisocial personality. Whereas those adolescent limited offenders consist of normal offenders whose delinquency has social causes. So now I wonder whether or not we have systems or programs being put in place into these rehab centers in order for these children to be properly rehabilitated, Madam President. Because you have to have separate and different treatment plans for each category of offenders. Because on one hand, the adolescent limited offenders, their delinquency is constrained to their period of adolescence, whereas the life course persistent offenders, theirs extend for the duration of their lives in some instances. It's more difficult to have them rehabilitated. And there must be some system being placed in these rehabilitation centers, Madam President, where they are kept separate from each other. And one other bill in which this omnibus bill touches on concern is that of legal aid representation. And it now expands legal aid representation to children who have committed motor vehicle offenses. And I don't know if the Legal Aid Advisory Authority has the capacity in order to properly manage this new workload that they will have. Because I know the Attorney General would have mentioned that he's going to set up the public defender's system, but I don't know how much more different that is from the Legal Aid Advisory Authority. So I am very hopeful that in the upcoming budget that is going to be read soon, that we see some increase in terms of the allocations for that department, the Legal Aid Department, so that they can hire more lawyers, so that also the DPP's office can hire more lawyers, so that we can properly treat with our criminal justice system. And I am hopeful that this government has 2 years into government again, so maybe you can build one court or fix the existing ones you have before you employ 15 foreign judges in Trinidad and Tobago. And I thank you very much, Madam President.
Senator Mahabir.
Thank you very much, Madam President. Madam President, before I begin my contribution today, I would like to deviate a little bit and make a point that is not strictly within the keeping of the bill, and that is, on the 31st of July, 2017, I applied for a driver's license, and I had to pay cash. And since then, I have been behind the Minister of Transport to ensure that there is a links machine at the Caroni station. And today, the Minister of Transport has advised me that a links machine a year and 2 months later has finally been installed in the Caroni station. I do not know what the Honorable Minister had to do to get traction with the public service. And I do not know how complicit the Attorney General was in this particular process. But I want to commend the government, Madam President, because it may be one small links machine. It's a massive change in payments in Trinidad and Tobago. And since that Caroni problem has been sorted out, I feel convinced that by Old Year's Day 2018, every single government department in Trinidad and Tobago will now be on a system of electronics payment. So we are making progress on that particular front. And I commend the Honorable Attorney General and the Minister of Transport. And I hope they will continue to encourage other ministries to become electronic. And we did pass the payment into court bill last week. The only issue I had with that was the fee that was charged for payments, which was a $5 fee and a $6 fee. I understand links payments are now 75 cents. So that's certainly a move in the right direction. Madam President, this bill before us is an omnibus bill. I have counted some 10 pieces of legislation, and I have another recommendation to make.
The recommendation is this. When I read the bill, I saw 9 pieces of legislation, to my mind, were relatively non-contentious. And if I were to recommend, I know the Senate will consider it, that the bills which are non-contentious, Madam President, be sent to the Statutory Instruments Committee, so the committee becomes Statutory Instruments and the Omnibus Bill Committee, and they simply report on all those bills, committee made up of all members from each bench, and they would report to us on the non-contentious bill so that it's not subject to a full debate because chamber time is relatively limited, and we focus, Madam President, on the bill before us that is due for a debate. So that's for efficiency in the chamber, because chamber time, Madam President, is relatively limited. The omnibus bill, you see, puts me in a difficult position. If I were to disagree with one bill, it means, in effect, I disagree with all of them. And I agree with 9 of them, and I have concerns with 1. So I think we ought to be looking at that. And we have not been using our Statutory Instruments Committee effectively, in my mind, in the Senate. This is something to consider in the 4th session of the Parliament. Madam President, like most colleagues in the chamber, I, too, have a concern. I accept all of the others. They are relatively consequential, administrative in my mind. But in the explanatory notes, Clause 3 would amend the Supreme Court of Judicature Act, Chapter 401, to provide for an increase in the number of puisne judges from 49 to 64, as is required to facilitate the implementation of the increased judicial responsibilities prescribed by these amendments. It would also provide for a person who is a member of the bar of a Commonwealth country to be appointed as a judge. This is a contentious issue. There are 2 issues here. One, Madam President, is in relation to expanding the number, and the other is to expand the locale. We are expanding a number from 49 to 64. Let me focus on the number. The Honorable Attorney General, I am sure, is of the view, having done the due diligence, that he requires that number to sit on the bench so that the legislative agenda of the government and the amendments being proposed today can, in fact, be properly acted upon, and we will improve the state of the judiciary in Trinidad and Tobago. But, Madam President, we know that numbers in the judiciary will not simply be expanded with ease. One simply does not go out and get a judge just like that. A judge has to have certain qualifications. Senator Choate and Senator Prescott prior, Senator Ramdeen, made some valuable points on the requirements of the judge in Trinidad and Tobago. Let me, not repeating what they have to say, but analyzing the situation from my own perspective, indicate what I consider to be the important points of issue. Madam President, we know there is a major difference between law and justice. Law is what exists in those big red binders that we have in the Parliament. Now it's in an electronic format. It's the word. What is justice? I always look at John 8:7, which says, "He amongst you who is without sin." So it required that the judge put himself in the position of the accused so that he will make a determination. In fact, if adultery is a crime in Trinidad and Tobago, as it was in that holy book, and we were subject to the penalty of stoning, I suspect that the Contractors Association may complain that we have exhausted the supplies of gravel in Trinidad and Tobago. So fortunately, it is not a crime punishable by stoning in Trinidad and Tobago. But there is that difference between law and justice. Justice is the interpretation of the law, having understood the perspective, the experiences, the historical context of the person who is accused. And similar to Senator Choate's position, I too am in agreement that a judge must understand local conditions. And I will come to the Honorable Attorney General's point with respect to special tribunals, etc. But should the judge not understand the history of Trinidad and Tobago, or the country in which he is sitting in determination? Take, for example, Madam President, this issue of marijuana, cannabis, ganja. I was told by Mr. Mahabir, that is my father, that when he was 10 years old, he would ride from Cunupia to Chaguanas to the Lion store of House for Mr. Biswa's fame with 5 cents given to him by the pundits in Cunupia to buy 5 cents worth of ganja so he could take it back to the mandir, and they had their ganja before they did their puja. He told me that 2 weeks ago. I was told by a retired judge, very close friend of mine, that when she started practice, she actually saw a license to sell ganja. Subsequently, marijuana became illegal. At one time, it was legal. Now it is illegal, and we may come to the time sometime in the future when it is decriminalized. We need to understand why at certain times certain things are criminal offenses, and at certain times they are not. The law is a living organism, and we need to understand the historical context in which people break the law. Because, Madam President, I could imagine someone accustomed to smoking his ganja in 1935 being told afterwards, you can't do it. He might be in a little state of a panic here, because if that's what he needed, then it meant that he was breaking the law at one time subsequent to his practice. Now we are told maybe he could do it. So we need to understand the history. We need to understand, Madam President, this society in which we live. Certain societies have different mores and cultural norms. Recently, I saw on the news in the state of Florida, one guy harassing the wife of another man. The man whose wife was harassed comes up, pushes the other guy down. The man who is on the ground takes out a gun, shoots the guy who simply pushes him, kills him. And what was the determination by the police in Florida? They said there was a stand your ground law. Once you are in that kind of action, it is okay to kill a man. That is okay there. In certain parts of that jurisdiction, you will find it is okay, Madam President, to accuse someone of murder. That's okay. But don't accuse them of theft. These are honor societies. The cultural contexts in which crimes are committed must be understood if there is to be a fair determination. It is true, I know, that if we have judges who err on the lower courts, the cases can be appealed to in the higher courts. But the objective of passing law is to ensure that there is little by way of appeal. You want the determination to be swift. Madam President, one final point. A judge, any judge in Trinidad and Tobago, in my mind, must know whether lagahoos have rights. You must know that, because in my mind, a lagahoo is a person by day, and he simply changes his costume by night. He puts on bling, and by day he is guaranteed by Section 4 and 5 in the Constitution, and by night he is entitled to privacy. But, Madam President, there was a case in Trinidad and Tobago. Senator Choate perhaps knows that case. It should be in the textbook, because one citizen, and this is a capital case, not a magistrate's case, one citizen was accused of killing another man, and in his defense, senior counsel Israel Khan, I recall, argued that the accused genuinely felt that he was killing a lagahoo, and that this man genuinely believed that there was a lagahoo, and he murdered him, and there are no laws against harming lagahoos still on the books in Trinidad and Tobago, was acquitted. This can happen only in Trinidad and Tobago, and cultural contexts are therefore very important. And Madam President, I think that when we are looking at the judiciary, because we are dealing with justice and not law, we are dealing with justice. Justice, a sense of fairness, equity, because the determination of the courts have a great deal to do with the stability of the society. I will come back to that later on. We need, if there is a lack of confidence everywhere in Trinidad and Tobago, we must never have a lack of confidence in our judicial system amongst our judges. It must always be that if I have my day in court, I will be fairly heard and I will be treated fairly, regardless of whether I am with stature or without means. So that local conditions, in my mind, are important. And I think we have, in Trinidad and Tobago, consistent with what Honorable Senator Choate has indicated, and Senator Prescott, we have had a long tradition of legal training. And the Supreme Court of Judicature Act has indicated that someone has to have 10 years of experience. I'd imagine he must have distinguished himself during the at least 10 years of service. Individuals would know, and it's important for him to have distinguished himself so that when attorneys appear before him, it's with a measure of respect, knowing that the judge at issue is someone who has worked on the ground and he understands. It's not as if I have no confidence in his technical ability. I know he has had the experience, so I feel confident that his rulings will be fair. And so, Madam President, I am of the view that as far as it is practicable, we recruit in all arms of the judiciary citizens of Trinidad and Tobago, simply because of history, the historical context, and I think that judges should have training in the history of the country and in sociology. In fact, those two disciplines, history and sociology, seem to be important for us in this legislative chamber as well. Madam President, that point has been made adequately. And I want to persuade the Honorable Attorney General that as a matter of policy, it should be that the options are given to the citizens of Trinidad and Tobago because they would have the requisite other qualities, the qualities of understanding the society and the context and the history in which they are called upon to adjudicate. Let me focus, Madam President, on the extension of Clause 3, which says that it would also provide for a person who is a member of the bar of a Commonwealth country to be appointed as a judge. Well, the Commonwealth is made up of some 53 countries. All of us at one time, under British rule, all of us now, well, practically all of us in the Commonwealth now independent. But, Madam President, I want to refer, and I'm sure the Honorable Attorney General is quite aware of the Defense Act 1401. The Defense Act 1401 was amended in 1970. So I did my little bit of Nancy Drew as well as Senator Choate. Senator Choate, I only have read one Nancy Drew in my life because I couldn't afford others. It was The Mystery of Larkspur Lane. I think I read that. So having read that, I am able to do a little investigation, Madam President. And when I investigated the Defense Act of 1970, I saw there was an amendment. What was the amendment in 1970 of the Defense Act 1401, Madam President? It was exactly what we are doing today with the Supreme Court of Judicature Act. We amended the act so that officers of the Commonwealth could sit on a military tribunal in Trinidad and Tobago. Let me mention from that experience, so we have the experience. And it's true, it's not a high court, it's a military tribunal, it's a court-martial. But, Madam President, I sat on a tribunal as chairman as well. The Attorney General appeared appeared before me, so we go back a long way, I think some 22 years ago, and the powers that you have as even in an administrative tribunal are very similar to what you have as a judge. You are going to be called upon to the same strictures and so on, and I'm very pleased that the AG was a shining star then, and he has become even a bigger star now. That was 1996 to now, so it is, and I'm also happy to see him in the chamber today, because it would complete for me a span of an association with the AG. And AG, I know you know where I'm going. Because AG, I will mention a few names. Madam President, the senators in this chamber who are age 50 and above may be familiar with the following names: Obitre Gama, Achiampong, Acheampong, and Danjuma. Those over 50 will know. For the benefit of the younger senators, let's see who they were. We have experience with the Commonwealth, you know, in Trinidad and Tobago. It's not as if we must learn from history. Madam President, Colonel Danjuma hailed from Nigeria. Obitre Gama, Major General Obitre Gama hailed from Uganda. Colonel Achiampong hailed from Ghana, of which I will have more to say. These men, based upon the amendment, and the Attorney General knows exactly that Defense Act, and he knows where I'm going with it too, because these were men who came to adjudicate the sensitive trial of the mutineers, Rafiq Shah and LaSalle. And they found Shah and LaSalle, of course, guilty of mutiny. Shortly thereafter, they found them guilty of mutiny. Shortly, these men from the Commonwealth, and I'm going somewhere, Madam President, I want to assure you. Colonel Danjuma went to Nigeria and participated in 2 coups which are acts of treason. Madam President, Obitre Gama was summoned as soon as the trial in Tetron came to an end by Idi Amin to ensure that the administration in Uganda could become efficient, because apparently he was very talented. Idi Amin, who shortly before had, in an act of treason, deposed Dr. Milton Obote, the legally constituted government of Uganda. What about Achiampong? Madam President, these were the men we selected from the Commonwealth, and they were officers of the military with full powers of a high court. Achiampong from Ghana. Ghana is a country that is close to me. Madam President, I went to school with a colleague who became, we were in grad school together, he became the governor of the Central Bank of Ghana in 2012 to 2016. His name is Kofi Wampa. Both of us did our doctorals together. Brilliant guy. When Kofi became governor of the Central Bank of Ghana, I said, Ghana is going to go places. He was a bright. Ghana, I looked at Ghana more than most, Madam President. Who was the first president of, I'm coming to Achiampong, and I'm coming to our policy here that we're advocating after amending the Military Act. Madam President, the Kwame Nkrumah. Kwame Nkrumah, the star of sub-Saharan Africa. Who was Kwame Nkrumah? He was the one who led Ghana to independence. He, in the late 50s and early 60s, sided with Nehru and Tito and all those other guys to form...
Senator Mahabir, I have to first tell you that I'm thoroughly enjoying your presentation, but I need you to come to the point of the bill a little faster, okay?
Thank you very much. Madam President, since I have a lot to say, I will get to the point. The point is, Kwame Nkrumah founded the non-aligned movement, but the point is, we have had an experience with Commonwealth administrative, with judges before, and it was not a good experience. What did Achiampong do? A year later, he went and he overthrew the government of Ghana. And so, Madam President, what can I conclude with that? In a military coup, and he was then deposed in 1975. What is the point I'm making here with respect to the Commonwealth? And with respect to the Commonwealth, Madam President, is this. For the people who participated in that military tribunal, it was okay to condemn someone for mutiny, but an act of treason was quite acceptable. They conducted treasonous acts in their country. Those acts of overthrowing a government are acts of treason. So, Madam President, when we say we are going to the Commonwealth, we want to make sure that we understand what we are talking about. Senator Choate alluded the point. The Commonwealth is simply a group of countries which happen to have been colonized by England. But to think that we have the same culture, the point I related earlier, to think that we have the same culture is not at all judicious. We differ radically. Madam President, when we look at the practices in the, I would like to ask myself some questions. I don't know where this came from. I know why in 1970 we would want to expand the Military Act. Why would we want now, to get to your point of relevance, why would we want at this point in our history, it has to be made abundantly clear why we would want to expand the pool of judges to the Commonwealth, not the pool of lawyers. Is there any agreement, and the Minister of Foreign Affairs is here, is there any agreement amongst Commonwealth countries, international agreements that we are signatory to, that says that the judges of one Commonwealth country should be free to practice in another? Or is it, Madam President, we are making a concession for judges from other Commonwealth countries, and there is no reciprocity? This is a concern that I have. Whenever we enter into this agreement, is it that judges from Trinidad can then go and practice in New Zealand? Is it that there's an international agreement that judges from Trinidad and Tobago or CARICOM, let us say, can practice in Australia? I am not seeing reciprocity, and this concerns me. Because someone defending the public interest, I can tell you, Madam President, Commonwealth countries don't treat each other equally. Why are we making this concession? And I'm not sure what I, as a representative of the people of Trinidad and Tobago, am getting for the people of Trinidad and Tobago. Take a simple example. And so the Honorable Attorney General, in his winding up, I am sure will let us know where there is reciprocity. You see, the issues are as follows. And I'm coming now to another point, which might be because there was no explanation as to why we are spreading to the Commonwealth. Madam President, we need to understand certain things. The Commonwealth is made up of a large number of countries, different stages of development. Whenever I travel to Canada, I need a visa. Canadians do not need a visa to enter Trinidad and Tobago. You see, this is the lack of reciprocity to which I'm talking about. So if we are going to say the Commonwealth is one family of nations in which all of us have a common kind of pool with respect to international law, we are misplaced. We cannot get into their system easily. Why should they come to us with ease? Madam President, I understand the Honorable Attorney General's position. The Honorable Attorney General, I know, is of the view that there might be certain cases where there would be a need for specialized judges, and these specialized judges may have to be recruited outside the CARICOM region. After all, Turks and Caicos and Nevis and St. Kitts and Montserrat, do I understand, have a need to rely on Trinidad and Tobago to assist with its own administration of justice. And the reason for that is they are very small jurisdictions. What about Trinidad and Tobago? We seem to be very self-sufficient. We seem to have adequate skills. But I understand there is one class of crime that we may not have the expertise. Take the case of financial crime. When I look at Trinidad and Tobago on the prosecution of white-collar crime, and I see that the SEC, Securities and Exchange Commission, has not been able to bring a case to prosecution since it was created in 1996, so that 22 years later, I am still waiting for a case to be prepared, for a binder to be sent to the DPP for financial crimes which have been committed. Where is the FCB, IPO, CLICO, and HCU? We are having difficulties prosecuting these crimes. And I am of the view that when I look at the Commonwealth, I see the expertise does not lie there. It may very well be that the Honorable Attorney General may have to call upon judges from the United States of America, a complete different jurisdiction, to prosecute some white-collar crime here. Because you see, our SEC law is very similar to the law that they have there, and they seem to be doing very well with respect to prosecuting white-collar criminals. So I don't know if the Commonwealth itself has any particular unique talent in these special areas. I have not seen the white-collar crimes of the type of Madoff and Stanford being prosecuted in other, even developed ones like New Zealand and Australia and Canada. I certainly see the prosecutions in the United States. So there is certainly a case for getting specialized judges, but not necessarily from the Commonwealth. The fact that we share the same legal system does not mean that only judges there will understand financial crime in Trinidad and Tobago. Reason is, Madam President, financial crimes are now global. We're in a global arena. The crimes, computer fraud is widespread, and we need people with a technical expertise who may not reside in the Commonwealth. So, Madam President, I have a proposal to the Honorable Attorney General. And if the concern, unless he is able to convince me that there are good, clear, and cogent reasons for expanding to the Commonwealth, my reading of of the Commonwealth is that they did not give a good, lasting impression here. Our culture is different, and that we happen to have had the same colonizer. That is all. We have, if we were all colonized by the French, and we were, as in France, they do have their similar grouping, and we could have been colonized by the Dutch as well. The fact that you have a common colonizer does not mean that you have a common culture. And this is something we need to be very cognizant about. We need to expand the number of judges. We need to expand the number of qualified people. We need to get the best of the judiciary, or the best of the legal profession in the judiciary. Madam President, how do we do that? Given the salaries which are paid, you see, let me get now into labor market economics. The salaries which are paid will, to a large extent, determine who you attract. We have a constraint in Trinidad and Tobago. This is the Salaries Review Commission. Well, the Salaries Review Commission is enshrined in the Constitution. I can't say yea or nay on their rulings. I must live with them. But, Madam President, there is a particular piece of legislation that is well within our control. And that piece of legislation is Act 602. Let me spend a bit, and I want to solve the problem. If it is that we want to get the best and the brightest in the judiciary, we cannot amend the Supreme Court of Judicature Act, and not in my mind, and we have amended 9 other pieces, and we have left 602 untouched. 602 is the Judges' Salaries and Pensions Act. Pensions, let me spend a few seconds on pensions. Madam President, compensation is made up of 2 forms. And we want to get the best in the judiciary. And I'm saying going to the Commonwealth is not the way to go. The AG knows when I criticize, I have a solution. Going to the Commonwealth will not get you what you want to get. And the AG and the opposition and the independents would all like to get the finest legal minds in the judiciary of the Republic of Trinidad and Tobago. We need to build an institution. We need to ensure that an institution which has been under attack over the last little while can move on, and we continue to attract the best that the legal profession, and I tell you, Madam President, when I interact with the members of the legal profession, I am convinced that Trinidad and Tobago has the finest minds anywhere you will find in the law, administration of law, the understanding of law, and on rights in Trinidad and Tobago. So the problem is this: what does 602 have to do with the Supreme Court of Judicature Act amendment? Madam President, I can't see how you can amend one and not the other. It is inconsistent. Inconsistent because if you want to expand to 60+ judges, you need to know what you are going to do to attract the best 60+ you can get. This is a unique labor market. It's not each and everybody who could become a judge. You need to have mind, head. You need to have the heart. You need to have analytical skills. You need to have the temperament for the business. But, Madam President, what is the economics of the matter? This is the reality. If, as a judge, you must retire at 65, it is my understanding that for a period of 10 years afterwards, you can't practice, so you can take your first case after you have left the judiciary at age 75, and usually, given medical advances, a professional can live for 20 years post-retirement. We need to look at retirement. Retirement, Madam President, has two issues. One is longevity. We are living longer now. And the other is inflation. Inflation means, and I've heard the cries of the judiciary, and I'm going somewhere, and the AG knows where I'm going. We have heard a Chief Justice retired in the public domain who is retired on full pension, indicating that he cannot make ends meet. Madam President, it is understandable that if you can't make ends meet on a full pension, then clearly the bulk of the members of the judiciary are experiencing, the retired judiciary, are experiencing grave difficulties in managing and paying their bills. Now tell me something. You want to get the finest in the legal profession, and the finest in the legal profession will ask themselves the following: why should I give up a lucrative practice which is paying me a decent sum, from which I can save a more decent sum, and make provisions for my retirement, and to join the judiciary, which pays me a lower salary, and when I retire, no one is...
Senator Mahabe, you have 5 more minutes.
Thank you very much, Madam President. When I retire, no one is there to look after me. So that the logic of the situation is that we'll not look only at salaries, we'll look at the retirement of judges. And Madam President, this is a problem which should not have arisen. Because if I were a young lawyer, and I'm a bright lawyer, and I heard a Chief Justice say that he can't make ends meet on his full pension that he had, I know immediately that, you see, that part of the legal profession I want to stay out from. And we have immediately killed the intent of this bill. So let us be sensible, and let us be fair, and let us understand, Madam President, that it is within our power, live with the Salaries Review Commission. I never quarrel with them, enshrined in the Constitution. But, Madam President, in the 10th Parliament, there was an agreement. Government, well, now in opposition who were in government then, I was in Parliament, I was in the Joint Select Committee. We had agreed to revise this particular bill with the Judges' Salaries and Pensions Act, and I simply will recommend to the Honorable Attorney General, in the 4th session, simply implement that which was agreed upon on this Judges' Retirement Bill, and you could see the quality of people you will have entering it. Just implement the agreement. You agreed to it. I agreed to it. Senator Mark's party agreed. There was an agreement. But you know, Madam President, important matters need not be lumped together. We lump the judge's business. That is an important matter. Deal with it. If we don't deal with it, everything will collapse. Deal with it. I have a few more minutes. And this is going to be my last session, AG, so please forgive me. Yeah, this is the last contribution I'm making, you know. Madam President, there was a problem. We lumped that and it got lost. Deal with the Judges' Pension Bill. Madam President, there was an agreement for senators to join the pension plan. I was shocked when the government voted against me on that. I am leaving and I want the government and the opposition and the opposition abstained on a critical matter of having all members of the Senate join the pension plan. What will it cost the government, Madam President, for the Judges' Pension Bill? $1 million a month. What will it cost to build the institution of Parliament? $50,000 a month. I use foreign use theater. Madam President, this is my last contribution in the Senate of the Republic of Trinidad and Tobago. Come next week when Parliament is prorogued, my resignation takes effect. Madam President, if you will permit me 30 seconds to engage in some evaluation. If I were to evaluate my own performance, I have to say one thing. I hardly ever won. But I think observers on the outside would say, at least he always fought. Thank you very much, Madam President.
Senator Obika.
Thank you very much, Madam President. And as my professor has taken his seat, I would like to say that I enjoyed his company, and I also welcome you back as well. So, Madam President, I want to begin where Professor Marbury left off. But I want to start by speaking to one key issue that this bill really seeks to address, which is the psychological development and protection of children in Trinidad and Tobago. And in preparation for this debate, I took a departure from my usual focus on the numbers and tried to get to the story behind the children and the persons who our children would be in the care of regarding when they are offenders. Now, whilst I can say that, I can't say who I spoke to because, of course, those persons may have some challenges explaining themselves. But one document that was passed to me is the Eric Erickson 8 Stages of Psychological Development. And they wanted me to focus on adolescents, 12 to 18 years, regarding the teens and the need for developing a sense of self and personal identity. You know, and what this person who is basically involved in the protective environment of our children who become offenders stated, Madam President, is that children don't have coping mechanisms to deal with adolescence, all right? And mentioned looking glass theory and so on. But what that individual drove at was the requirement for peer mentorship programs, all right? Now, whilst the bill in clause 11, I believe it is, let me just make sure I'm correct, clause 11, really encompasses what I'm going to focus on in its entirety. I want to just take a departure from that just to deal with clause 3 in reference to what Dr. Mahabir commented on at length. Now, Dr. Mahabir reminded Trinidad and Tobago of the debacle that was the military tribunal involving Achampong, Danjuma, and the other military top brass, where they found Rafik Shah, LaSalle, and many others guilty of mutiny. But what I want to also remind Trinidad and Tobago of, and it's captured in an article titled "Three Eminent Jurists" by Rafik Shah of January 25, 2014, where he stated that three eminent judges, Chief Justice Clement Phillips, so acting Chief Justice Clement Phillips, and Aubrey Fraser and Telford Georges, at the time, three of the most eminent jurists in the country, they, having heard their appeal, they quashed the decision of the military tribunal. So here we have it, a perfect example of where you have three foreigners who are convinced, and foreigners who are not from the Caribbean, all right, who are convinced and were handed down a conviction of mutiny, albeit going back to their own countries and overthrowing the governments. But when you put it in the hands of local judges, they quash that decision. So, Madam President, if there are other examples that run against this, they may not be as scandalous or as prominent as this case. I want to just share a simple story that was given to me by one of those soldiers. And he said that one of the persons in the military tribunal, I won't say who, told him that if he were to be in his country, he would have been killed already. And that soldier reminded the senior officer, who was a foreigner, that this is Trinidad and Tobago. And I want the Honorable Attorney General to always be reminded of that fact, that this is Trinidad and Tobago, and we have to be careful as to who we bring here to decide on matters that are important to us. So, Madam President, that will be the end of my sojourn into Clause 3, and I will focus on Clause 11. Because really and truly, this bill has so many parts that each part on its own could be the subject of a full debate, okay? And because you don't have that luxury, I want to focus on a narrow aspect of it. Now, I want to turn our attention to the United Nations rules for the protection of juveniles deprived of their liberty. That is the Havana rules. Sorry, and in particular, Rule 67, where it states, and I will just read the first sentence, all disciplinary measures, and I quote, sorry, all disciplinary measures constituting cruel, inhuman, or degrading treatment shall be strictly prohibited, including corporal punishment, placement in a dark cell, closed or solitary confinement, or any other punishment that may compromise the physical or mental health of the juvenile concerned. They also went on to state reduction of diet and the restriction or denial of contact with family members should be prohibited for any purpose. Now, Madam President, if we were to examine this, which really is something that is agreed to by the nations of the world, all humanity, okay, that placement in a dark cell, solitary confinement, reduction of diet should not, must not, at any time, for any purpose, be punishment meted out to young offenders who are classified as children. And given that the Honorable Attorney General, in piloting the bill, referenced the age of 18 years and under 18 years, that is. I want to turn our attention to the fact that new section 17A prohibits certain forms of punishment to a child placed in a children's home and makes it any offense to perform such forms of punishment. And if we were to visit page 37, Madam President, of the bill before us, and we look at what those prohibited forms of punishment are, Madam President, and for the purpose of the listening public, I wish to just read those 4 bullet points, A to D, into the record. A child placed at a children's home shall not be subject to A, corporal punishment, B, restraint or force as a form of punishment, C, the reduction or change of diet as a form of punishment, or D, the restriction or denial of contact with family as a form of punishment. Now, that mirrors closely what I quoted from the Havana rules, that is Rule 67. However, I am not seeing placement in a dark cell. I'm not seeing closed or solitary confinement, Madam President. It's in the regulations. Okay, so the Attorney General is indicating that that would be found in the regulations, and I'm very happy to hear that, because that would have been something that I felt should be focused on. So given that it is in the regulations, I would happily move on and focus the rest of my time on other things. Now, Madam President, if we were to look at what obtains, okay, and I sought guidance from counsels to my left and right regarding what I should say that could compromise the process of apprehending or protecting young offenders in the system. But if I run afoul of anything, I beg of the Honorable Attorney General or your good self to stop me so that I don't prejudice any systems that are in place for the administration of justice at our nation's schools, etc. Okay? So, Madam President, one of the things in my interviews that I conducted before coming was the issue of holding parents accountable. Now, I'm not sure if it's captured in this or other forms of legislation, but the person who's involved in that process of apprehending young offenders and trying to reform them stated that there should be some mechanism for holding parents accountable. And one of the recommendations that the person made was, even beyond holding them accountable, there should be training for young parents. In fact, they went further to state that there should be training for parents who are teenage parents, or parents that became parents in certain circumstances that we don't want to mention here that may have affected their ability to be good parents going forward. So in that way, you basically attack the problem from the root so that you protect the family situation of the children. Okay? Now, Madam President, the individual also went on to talk about and this is where I request your guidance regarding caution, the juvenile holding cells in Trinidad and Tobago, and indicated that there are that the system requires more attention to this. The relatively new police stations have juvenile holding cells. I won't state which stations, okay? Because I don't want, if a child goes to a particular station, other children will know that they are being held there, and that can cause a stain on that child's reputation going forward. But what in essence they are saying is that we need to retrofit or improve the police stations across the country so that they can accommodate juveniles in a manner that is in accordance with modern and best practice. So I'll move on to another point. The person also indicated that officers cannot approach schools, for example, in marked police vehicles if they have to apprehend a young offender. And the reason for that is that it would affect the psychosocial makeup of the child, and they won't want to run afoul of that. And they pleaded for more unmarked vehicles for the police service in that regard. In addition, Madam President, they raised some issues regarding the child court in Faizabad, but I will raise those quietly to the Attorney General because I think I will run afoul of what I forewarned. The other issue is regarding social workers. So in terms of protecting and preventing youths from falling through the cracks, as we say, what they indicated is that there should be one social worker per school. And at the moment, there is a the ratio is roughly 2 social workers per school. And that given that some schools have relatively large student populations, 700 to 900 and plus students, as you may have it, that it should really be 1 social worker operating per school so that they can develop a better appreciation for the personal and the individual nuances of the children in the student population. Okay. Another point that was raised was regarding the victim support unit of the police service, and there was a plea for more personnel to be offered in terms of police officers who are trained, of course, to be offered to the victim support unit across the country in the various policing divisions. Regarding young parents or parents who, in the whole vein of preventing young offenders from emerging, what they also mentioned was the whole issue of the paternity test, for example, which helps in bringing the biological parents together and at least identifying them in the interest of the child. They indicated that the cost of the paternity test tends to be a barrier, whereby you have to pay $2,400. That's the charge that I was informed of. $2,400, and it's conventionally paid half by the male and half by the female. Okay? And what the person indicated that, can you imagine a situation where you have teenage parents, or a teenage parent, let's say in the case of a female, who already has to stand the societal impact, which most times is negative from family and community, of being a teenage mother, and now having to find milk and sugar and so on, and on top of that, having to find $1,200 to go and secure this paternity test. So for the social services of the government, at least the Minister of Social Services, we want to take a look at this issue, because this is a complaint coming to me that I am sharing with the nation regarding the inability of persons to participate in paternity tests for children because of their financial situation. So in all, in terms of persons who are involved, this individual who is involved in the sector of reforming children, rehabilitating children who are young offenders, they want to remind the nation that parenting workshops can be something that can be looked at by the government, a peer mentorship program, okay, and also more psychosocial.
Senator Beaker, I'm understanding your presentation, but I think that you're going very wide. Even though it's an omnibus bill and is dealing with several pieces of legislation that treat with children, I need you to be a little more specific to clauses in the bill and to the specific measures being introduced in the bill, okay?
Okay, Madam President, basically, as I said, I'm anchoring most of my contribution to Clause 11, which basically speaks to the way in which children are treated in terms of rehabilitating them. I know sometimes I may go a little wider. It's only because I really just wanted to bring this reportage to the House. And this is actually the end of this point. So it's a summary. The point they wanted to bring was in the DPED in education, to place greater emphasis on child psychology, because many of the teachers complain that they don't have the tools. Myself, being a secondary school teacher at some point in time, you recognize that many teachers don't have the tools required to deal with the psychosocial fallout of young offenders. So I want to move on, Madam President, and to really look at, sorry, I want to look at some aspects of the bill essentials that I felt. So if we look at section 11A, I'm just refer to the proper part of the bill. This is the Children's Community Residences, Foster Care and Nurseries Act. Right. So it says that subsection 1 is amended to ensure that the authority, when serving a notice of revocation to a licensee, do so no less than 14 days prior to the date of revocation. And I want to ask a question to the government, that given moving house for anyone, fatherless a child, tends to be a traumatic experience, how will children be so impacted if, in effect, we only afford them, in some instances, 14 days? And therefore, whilst it may be neat to extract them with haste, then we would also want to consider protecting them mentally in that process. So that's one issue I want to raise there. Also, regarding the fine that is attached to punishment, $50,000, I think no amount of money can correct the issues. So persons who are involved in the business of child rehabilitation, I think at this point in time, that particular clause in the bill should be promoted nationally in terms of a nationwide education campaign, so that all and sundry can be aware of what the fines would be if they run afoul of the law, all right? Because many times these things get lost in translation for persons who are not inclined to understand the law, all right? Regarding other measures that are recommended, I want to step aside from the bill and promote an example that I came across just today, Madam President. And this example is actually from an organization that has their work in the Lavantil community, all right? And they're focusing on reforming children, but more or less giving them a leadership platform, all right? So I guess I can mention the name of the organization. It's the Black Agenda Project, all right? And one of the focuses that they have is agriculture, and they are using positive examples from professionals to come into the communities to give basically a sense of an outlet, as many of them may not feel that they're in close proximity or that they can touch persons who are success stories. So that program I want to promote, and I believe that maybe the government, whilst protection of the wider society is important by housing children in rehabilitation centers, may want to look at also investing in these types of projects that can do more in the community. Now, Madam President, there was a Joint Select Committee report that's available online, the Human Rights and Equality and Diversity Committee, the third report on it, and this was in 2016, I believe. The second session of the 11th Parliament, 2016-2017, on the treatment of child offenders at the Youth Training Center, St. Michael's Rehabilitation Center, and St. Jude's. So I just want to point to some recommendations there and probably ask some questions regarding where we are. And hopefully in his wrap-up, if the Attorney General can answer some, would be of interest to me. Now, one of the first recommendations that they made was that strategic plans be drafted for those three institutions mentioned. And it would be good to know how far along we are and, of course, what is required to get that done. Another was the implementation of a children's registry to track the progression of children in conflict with the law after they exit the rehabilitation centers. And this is a main concern for persons who are not even involved in rehabilitation centers, but simply children's residences. And there's one such place in Point Fortin who received children from court orders. And what the main concern of the administrator of that children's home in Point Fortin is that when the children leave the home, there is no mechanism and there is no process to protect and guide them. When most of us turn the age of 18, we still have the opportunity to benefit from the protection and guidance of our parents, or grandparents, or aunts and uncles, etc., because we may reside at those places. But those children are thrust basically onto the street, all right, in the hope that they can find a long-lost family member who may be willing to cooperate with them and so on. And I feel that there should be some focus on transition, greater focus on transition homes for young adults, all right? Another recommendation was collaborating with the Ministry of Community Development and Culture. And I want to know if this has in fact been done because of the lack of cultural programs at the St. Michael's School for Boys. And to me, seeing this in 2016, 2017 is very worrying for me, because I can clearly remember when I was at the age of 15, 16, involved in youth calypso organizing. We every year carried a cultural troupe to St. Jude's and to St. Michael's. And those children, they actually became, some of them became calypsonians themselves, or musicians themselves, you know? So I think that this is a project I would want to support, and definitely we can benefit from that. Now, it also goes on to talk about twinning YTC with YTEP and CPEP and so on. But I was a little disappointed, Madam President, that they didn't say UTT and COSTAT, you know, because yes, we know that there are different academic inclinations of persons. Some may be more vocational, focus on a vocational tech voc line. But however, we don't want to limit the opportunities to tech voc, but we want to make it as broad as possible so that maybe someone can be a medical doctor if they so choose. All right? So that's one of the conflicts I have with the recommendations of the committee. I believe that it should be broader. And I want to just say why I believe so. I was teaching a young student mathematics, and she attended a school in Mokurapu, all right? And I asked her, what do you want to be when you grow up? And she said, a doctor. And in the child's presence, the mother laughed. And the mother said, she cannot be a doctor because the school that she goes to does not prepare children for that. She has to limit her expectations in life. So I think if we take the moral of that story, we should not be preparing our children for anything less than their fullest potential. And whilst a career in Tech Voc is great, we want to make sure that those who want to go beyond Tech Voc education, that they have the access to do so. And also those who want to be excellent at plumbing and so on, because they can match that with entrepreneurship and be their own businessman or businesswoman, as the case may be. So that's where that is concerned. Now, Madam President, on this bill, much has been said regarding the requirement of foreigners to be aware of our local scenario and conditions. So I don't need to go there. I simply wanted to point to the government that there are alternatives to what the public still perceives to be incarceration of children, and that we need to take a holistic approach to development of our nation's youth, from the school, kindergarten, Tech Voc, at the centers of learning, so that all children have the opportunity to be the best that they can be. And I thank you.
Senator Roach.
Thank you, Madam President. Madam President, this debate has produced very able and informative contributions from members of this Senate, and which I commend and appreciate very much. This debate, which basically proposes to purpose of the Miscellaneous Provisions Supreme Court of Judicature Act Bill 2018 is to amend 13 pieces of legislation and to allow the streaming of the processes as it relates to the treatment of children matters. Madam President, my approach to this is somewhat very dispassionate in this instance. I think I am not so emotionally charged about what is being debated here today. Not that it's not important, but because I think it requires a certain measure of objectivity and impartiality in dealing with this. And like many of the other contributions I would have made, and coming at this point in time, a lot has been said. And my focus more or less will be along the lines of the amendments of the Judicature Act, which seems to be very emotional and very intensely debated here today. Before coming here, I also have had the opportunity of conferring with a number of my colleagues in the legal fraternity, some members of the ordinary public, who, of course, at the end of the day, have an investment in what type of judicial and legal system we are promoting. I will commend immediately the efforts of the government, of the Attorney General and his staff in trying to continue to bring before us legislations to help in advancing the administration of justice, which we all will agree is, for the last couple of years, unfortunately, has been taking some beating publicly for efficiency, for a number of other ills, which I'm not about to engage in. But to logically approach this thing, I mean, the section 3, or clause 3, seems to ask us to extend the number of judges in both the High Court and the Court of Appeal, right? That is one issue. And my immediate response to that would be, as has been raised by a number of the senators, is there really a need for such an increase at this point in time? That is a very basic and logical question in either supporting or not supporting a measure of this nature. If there's a need, based on what basis? Is it based on analysis, empirical evidence, as opposed to anecdotal type of concerns? And if so, the second issue would be then, therefore, where do we get these judges? Trinidad and Tobago is a population of 1.3 million people. I am not as emotionally sensitive, and I'm trying to choose my words carefully, sensitive as my other colleagues would have been in terms of where judges come from. Because I have had the privilege, I would say the privilege, not an entitlement, to have practiced in a number of jurisdictions internationally. And I have been welcomed there, and I have benefited from there, and I have returned where I have contributed and believe I'm making an able contribution to my society in the legal fraternity and in other aspects of everyday life. And I will pretend to be, at this point in time, the devil's advocate, because as we look at technology, the world is becoming more and more a global village where there's a lot of cross-pollination in terms of culture, socioeconomic exchanges, and legal, and as well as legal. Trinidad Carnival is promoted in many other significant metropolitan societies right now. In terms why I'm saying that, because there's a concern that if you bring judges from wherever, that they may not necessarily understand the nuances of our culture. Technology is quickly putting that to be something not of a significant concern, because we watch all type of information which is instantaneously brought in our homes without us even. We sit inside of here, we can pull out our laptops, our smartphones, and get any type of information on anybody, anywhere, at the tip of our fingers. And that in itself influences culture. It influences how people think, it influences how people behave, and therefore it will be some kind of bipolar. In one instance, you are saying that you don't want these outside influences because they will not understand. But at the same time, you can speak, many of us and many young people can speak at length with authority with the cultures in other countries because of the advent and the increasing role that technology is playing in our society to evaporate and make us more and more a global village. So there is the concern, I understand, and I, as a practitioner myself, the concern that when you're before your lordship, or that what you are presenting in the context of your peculiar domestic circumstances will be fully appreciated. But by and large, as I'm saying, because of this global way and because of technology, that is not that severe as it would have been in years gone by, even when I first came out to practice almost 29 years ago. What I will certainly have an open mind with the Attorney General, because he had a lot on his plate. It came out from the debate from eminent senior counsels on the independent bench as well as counsels in the opposition bench, that if he can learn and inform not only us, but the public, who at the end of the day are the beneficiaries, are supposed to be the main beneficiaries of any improvement in the administration of justice to understand why it is at this point in time we are seeking to increase the number of judges. Now we know, and I think common sense will lend itself, the fact that you increase the number of judges because you have a large volume of cases coming before the court may not on its own may not necessarily be the answer to it. It may be inform the slow pace of the wheels of justice. It may not necessarily be because of an insufficiency of the number of judges. It may be because of the system itself. If we look within the, I have read the commentary and the contribution made by the law, by LAT, the Law Association of Trinidad and Tobago, and they say basically that in principle they have no problem with the increase of judges, but their concerns seem more to rest on the second issue, which is where they're coming from. So I wouldn't want to get to that at this point in time. What I want to look at, I mean, as much as the Law Association focuses attention on this piece of legislation and made their contribution, is that when we really look at our judicial system, the insufficiency of judges per se does not of its own either advance or retard the system of justice. A critical role in the machinery and the space at which justice is dispensed in this country has to do with the very members of LAT. Their efficiency, people take on in the law association, people take on more cases than they can competently deal with. I have been in court many, many a times, and I've heard this lawyer is not available because he or she is in another case and so forth. And sometimes you know, and it's a very common practice to hear one lawyer involved in about 5 cases in one day before 5 different judges. That in itself leads to a clog and a sort of retarding of the dispensation of justice. And it's something that the LAT should look at as well. Should be, in those instances, curtail or set up, be innovative. Probably I don't know of any other jurisdiction where it is done, but we could be innovative and be leaders. Instead of lawyers just be able to take any amount of cases on a regular basis in any term. Limit them because due to their number of years, seniors have a certain, over 10 years, under 10 years, so on. Take a number of cases that you can only deal with within that period of time. Once you are completed, whatever amount you can get up, you have a maximum that you can take. And in that way, too, what it will do is to free up more work for other lawyers who are underemployed to be employed, who will never see this work because work sometimes circulates around a certain clique of people because of contact or other reasons. So that could be another way. But that, as much as it may seem, as I'm saying, I'm being the devil's advocate, that is a critical concern in the efficiency of dispensation of justice in our country. The availability of lawyers to do what they take on. We have heard when we were publishing some other bill through these chambers where they were saying there was a paucity of criminal attorneys because there are insufficient lawyers that go into the criminal arena, and therefore it's difficult to get representation. So there are a number of reasons that can cause to retard, and also that can be corrected, looked at, that can help to speed up the efficiency of our judicial system. So I'm just inviting the Honorable Attorney General in his winding up and his response to a number of the issues which have been raised, and this is not being raised by me alone. What is the basis, and what at the end of the day, if these judges were to increase, exactly why? Is it because just numbers, or is it part of a compendium of other issues, other measures that are being compiled and being promoted that will ultimately lead to an improvement in the system at the end of the day? So this is just one of a continuation of what is going on. Now, in terms of, as I said, in terms of judges coming from elsewhere, I've heard member senators, I have the Law Association as well speak about, first preference should be given to the locals who have trained, who have practiced here. One cannot argue with that. I mean, as I said, we have a small pool of talent of people here. Just like when I was advocating sometime many years ago before being in the chambers that we should have a fixed term for prime ministership. And it was pointed out to me by members of the same association saying that, our pool is too small to have limitation of office for the prime minister, 1.3 million people is a small group. So similarly, in terms of enhancing the quality judges that may help, if we realize there's a need for judges that we can access to assist in making our system more efficient. I really have no problem. If we start, as you say, you start at home, it's not available, you look to the region and you look elsewhere. The Commonwealth, we engage in interchanging and cross-pollination in many things. In laws, we use cases from Australia, from India, from Pakistan, from South Africa, from many places, from Canada, from New Zealand. You know, so to inform our laws, we still continue to take laws from international jurisprudence to help us to move forward in what we're doing. So the world is becoming more and more homogeneous, right? As opposed to this distant, ancient, alienated type of world that we once lived in. That was difficult to understand what is going on here or there. Information is more rapidly available to us, and our movement has become much more significant and increased and easy. So people are easy accessible in cultures and in and out of cultures on a regular basis. We do business, we do all kind of things. We have practitioners here who go up and down the islands, who sometimes go to England. I practice in the United States of America, I've practiced in South Africa, I've practiced in Congo, and so forth. And you come back here and you fit into these places because essentially most of the time you're dealing with the law, with the rule of law. And culture can be influenced, yes, but I'm saying that is not to me that should not be a significant obstacle if there is a need to increase the pool of lawyers of judges in our jurisdiction at this point in time. So I will ask the Attorney General that in his wind up, I would appreciate some further enlightenment of why it is we are looking to increase, whether it's by 2 or 1 as the case may be, and if so, if that is the case, then if you will give consideration to having his amendment to some extent to take care of the concerns that in some instances, first preference should be given to locals, Caribbean people, and then by extension, the wider Commonwealth as the case may be. And that is what I see as the crux of sorry? Yeah, that is Senator Mahabe is trying to tell me I must not talk so much. I don't know why.
Which he actually was, this is now the time for the tea break. So if it is that you are finishing, okay, all right.
Much has been said. Much has been said. Madam President, I just want to petition the Attorney General that much has been said, which I can associate myself with objectively in terms of querying whether or not there is really a need for the increase in the complement of judges. And if so, I can associate myself with the fact that without being too antsy and emotional about the wider Commonwealth, you can have a tier. You start locally, you come regionally, and then you go internationally. It still will have access to competent people, as the case may be in those circumstances. Madam, with that, I thank you very much.
Senator Crease, you will, when we resume, I will read. So, Honourable Senators, at this stage, we will suspend and we will return at and we will return at 5 minutes past 5. So we are suspended until 5 past 5.